Well, we're here in litigation class, and we're going to work a little bit on actually session 9, which is chapter 10 of your book. And this is about interrogatories, and I'm going to warn you that this is probably going to be pretty long, and what I'll probably end up doing is actually doing 2 of these in order to be able to cover everything that I need to cover. You can tell that the interrogatories are very important if I'm going to spend more time on it. And so there's a lot of differences between federal and state rules. There are some new developments with this electronic stored information, and so just more effort needs to be put into this than what we normally would. Well, let's first of all look at, and I want to warn you, like right up front, that there's going to be some definitions that I'm going to want you to turn in, and then what I want you to do is share those with me. That shows that you really are paying attention to these, and here again you get extra credit. And this is just a way that I can kind of gauge who's really watching these, who's really availing themselves of the opportunities here. You can pick up a few points. I think the overall extra credit is 100 points, but they're like 25, but there's not going to be 25 every session. There's going to be periodic just to check and things that I think are important. So like in interrogatories, obviously one of the most important things, very useful tool. So I want you to know basically some of these important concepts. Electronic, so the E is electronic, and then it's stored information, okay? ESI, okay? And what you'll find in the business nowadays is that that's it, that's all, ESI. They say ESI, and you need to know what that means. I'll get it again. Electronic stored information. So if you can't read my writing, at least you can hear me. So you got double whammy going here. So very important that you know what ESI is in this modern world that we live in. Some other issues that we're going to cover in this little video are the drafting of interrogatories. Where do you look to figure this out? And then we're also going to look at the answering. And paralegals are critically important in both of these areas of drafting and answering interrogatories. Now, a main place to look, find information is Rule 33. I started to jump ahead of myself here. Rule 33, and this is both federal and state. Okay, so it's the Indiana trial rules or the federal rules of procedure. Rule 33 kind of controls interrogatory. So I had one of the students, very kind, but indicated that my big belly, gets in the way sometimes of the information that I put on the board, and therefore you can't really see it very clearly. So I'm being very sensitive to that. I'm taking 2 measures to try to change that. I don't know if you've noticed or not, but I'm on a diet. I'm trying to lose weight, and then also I'm going to leave this up here and kind of step back out of the way better and give you more time. Another thing to look at is Rule 34, because Rule 34 is very important on this whole issue that we mentioned before on ESI. In the Indiana rules, we'll touch on this later, but it comes up again. There's actually kind of a safe haven rule regarding some of this ESI in terms of being in trouble for failure to respond, and so we'll get into that in more detail. And then another important rule that we need to touch on, and this is very different. This is an important rule here. Federal is very different, than state. Okay, very critically different, because the federal rules, and I will tell you that I experienced this, federal rules basically require that you do a relaxed kind of discovery type sharing. So you should turn over a lot of this information, and it doesn't even require motions, orders, any kind of subpoenas or anything like that. In other words, you file a lawsuit against somebody, you better have a packet of discovery that you can just turn right over, or you could be declared in violation. And if you get too cute with Rule 26 in federal court, then they could smack you really hard, and even for a plaintiff, they could dismiss your case if you come into it and you're really not prepared. I know a lot of guys that have a lot of experience in state court and have no experience in federal court get burned on that, because they come in and say, well, I got a good lawsuit, we need to get it filed here. But the problem that's different in federal court is you've got to come in prepared to turn over information right from the beginning. Whereas in state court, there is no rule like that. It is a real general rule about the process of discovery. It just kind of describes the different kinds of discovery, and includes a slight mention of interrogatories as being, a useful tool, in discovery. I think it's kind of weird that we look at the rules and look at waiting clear down until Rule 33 and even talking about interrogatories. If it was up to me, and I've done this before when I was just teaching the class in the classroom, I would talk about interrogatories before I even started talking about the depositions or anything else. I mean, I think that interrogatories should come first in the whole discussion in the process. But it's not that way. A lot of this content is pre-prepared, and so I just kind of have to follow somebody else's kind of marching orders, which is kind of sad in a way, but it's just the way it is. Under the federal rules, it's different under Rule 33 also, and I want to bring that to your attention. There's only 25 interrogatories. In the state rules, there is no specific set amount of rules. Now, what you do find, though, that are supplemental, there's a federal 25 interrogatory limit, but on the state level, there's no specific amount, but there are local supplements to these rules. So you've got to be careful. So especially if your office is practicing out of county, you need to get those local rules, and you need to figure them out right away. The reason is some of the local, like Marion County, and some of them have put changes in there, as some of them say 50 interrogatory limit. When I started this business, and this was way back, when we were actually using clay tablets, to write stuff down, and it wasn't that bad, but we didn't have such a thing as a computer, for example. It was all on, we thought we were doing great. We had an electric typewriter, But the big thing was we ran into a problem where, and lots of times, I would get 150 interrogatories. And it's just terrible. I mean, it would be, where did you go to kindergarten? You're talking about a car wreck, and where you got your knee broken or something, and they start out, well, where did you, go to grade school? And then, of course, clients even object when they're saying, well, how many times have you been married, And someone would say, well, that's not important, Well, it can be important, because you can have wives that say, well, you lied, you put money away somewhere, you hid your assets, just anything like that that can attack your credibility, that can affect the value of your case, even though you have a perfectly good case. Okay, so let's work our way through this. Like I said, it's probably going to stretch into a couple of different sessions here, because this is, so big and so compelling. The important thing here is take good notes on this, and turn in your notes so you show me that you're paying attention and you get the definitions and things like that. A simple definition of interrogatories is written questions, okay? And those are given by one party to another, okay? Now, one of the things that you can get into is that you can actually have situations where interrogatories can be served. Like, for instance, if there's already a judgment, you can get an order from the court that includes an order for what we call garnishment interrogatories, where you can try to collect a judgment by finding out where somebody works, how much money they make, if they have any other garnishments, things like that, in order that you can actually serve them. But generally speaking, when we're looking at interrogatories, we're talking about written question from one of the parties to another party. Remember, parties are parties to the lawsuit. There can be other parties, but they're not parties to the lawsuit. They could be witnesses, things like that. And generally speaking, witnesses are dealt with just a little bit differently. One thing to remember is that the interrogatories can be limited in scope, and they can be limited in number. The judge always has the option that he can limit the number of, interrogatories. Now, one thing when we talk about scope, they say that scope, it should be general in nature. Scope means, what are these interrogatories like about? Okay, now if you've got a limit of, say, 50, it better be about your lawsuit, You want to go out far afield and say, well, where did you spend your vacation last year? So that's not a very good interrogatory. General in scope, okay? You can go into things like, where do you work? Okay? Can get into detail about how did the accident happen, A big one that comes up, were you drinking that day? Had you been drinking before the car accident? Like a natural follow-up to the work is, how much money do you make? So some things like that. And so here again, it's just to try to get a basic framework about the person involved in this case. So you're just trying to get basic information to get started in this whole discovery process. And that's why I'm kind of saying that interrogatories probably should come first before you even look at doing a deposition, because you don't want to come in cold and do a deposition not knowing anything at all about the person or the case or their allegations. It makes for a lot more work. One of the advantages is that it's simple and it's inexpensive, okay? Okay, and basically there's no scheduling involved. Now, one thing is that there are deadlines involved, usually 30 days, okay? But you don't have to say, well, you need to be here at 11 o'clock on Tuesday, the 23rd, to, sit for your interrogatories. In other words, you just need to deliver them to me within 30 days of when you got them. Like I've said before, they are very complementary to other techniques like depositions, so they can be, very helpful. General terms, like I said, some of the disadvantages are, hope that everybody's had a chance to write that down. Some of the disadvantages relate to, it's only supposed to be between the parties to the lawsuit, okay? You have to get special permission to serve interrogatories on someone else. Now, here again, we mentioned earlier on about the use of deposition by written question, okay? That's your alternative, okay? And so that might be, and when you get into like geography where you got people far away and stuff, people want to look at other alternatives other than, like traveling out there. But the God's truth is, you just about have to go out there. I had some great success in doing actual depositions with witnesses where it's some funny stuff, but actually did a deposition of a witness in Denver. He identified the wrong person. You could clearly see he had no idea who robbed him, and so it really helped us in the robbery trial. The other one I had one time was a foreman in a factory, basically confessed right in the deposition that he had done an illegal search of this person's automobile. And so, just things like that can be very helpful in the outcomes of cases. And so sometimes if you've got witnesses, you're better off to really just bite the bullet, go over there and talk to them. Witnesses include, of course, experts like doctors. You definitely want to talk to them face to face and get that all tape recorded. The other thing that you have is you can always get letters and so forth for negotiation purposes from doctors, but once again, doctors don't want to show up in court, so here again, you're going to want to use a deposition in those kind of cases. So a lot of times with witnesses, interrogatories won't work. It's not a good option, but it is an important option in terms of when you're working with parties to a case. You need to get started off trying to find out what they know and what they think, about the case. Other disadvantages, basically it's not a cure-all. Still need depositions in a lot of cases. It sets you up good for depositions, but it doesn't take the place of it. Now, let me say this though. When you're working in a divorce, for example, and you have a real limited budget and you can't really afford to take depositions, interrogatories can be very helpful. If you don't see any real potential, for hidden assets and things like that, then a simple set of interrogatories is the way to go in a divorce. Quite frankly, a lot of people in the old days when I first started, they didn't do anything in a divorce. They just showed up, did the case in court, that was that. More and more I saw over time that really the lawyers, just to protect themselves, started doing more and more interrogatories just for self-protection, that guys wouldn't hide assets, and then later on the woman claims, well, I found out that he hid assets and you didn't even ask him about that. So that's a big area in divorces, and so a lot of times interrogatories can save you the cost of depositions, but it can be one of those issues where you got to make a decision. One of the things here that they say is no spontaneity, and I think I got to figure out how to spell that. Something like that. Let me check it here. Let me check. That's why I write this stuff down and get it correct first time. Spelled it wrong. Okay. So this is E right here. Okay, lack of spontaneity. Problem that you get into on that is people have time. They get the interrogatory, they read it, they sleep on it, they dream up an answer, and that's not always good. Or they can say, well, here's what really happened, and the lawyer, which I hate to even go there, but sometimes the lawyer will say, oh, you don't want to tell them that. We're going to lose our case if that's what you tell them, So one of the things too is that if you do tell the truth in an interrogatory, then you can change the defense to the case. You can, signal problem areas that they can, prepare for. So that it can be a problem, but there's really no way to get around it. Discovery is required. in this modern world, and interrogatories are a part of that. So you know, those can be issued. Here's the thing: when you get involved in terms of answering interrogatories, you can just answer the questions, okay, and you want to do that for most of them, just to be on the good side of the judge, or you can object. And you know, a lot of times people will object to some of the questions. Like, for example, if there's an interrogatory in there that says, you know, where did you go to kindergarten? How is that relevant at all? Okay? Now, I've had lawyers argue in open court, well, Judge, I want to know if this guy moved around a lot, kind of shows that the whole family's kind of shiftless, and, you know, which is kind of ridiculous. I mean, if you're in the military and stuff, you get moved every 3 years, so you don't really have a choice. This modern world we live in, people move around all the time. So to make an argument like that, it's kind of, you know, preposterous. That's something out of like 1930 or something like that. So basically, you can also say, you know, object because of a vague or irrelevant comment like, where'd you go to kindergarten? Can be a vague question that's overly broad. Man, I'm telling you, sometimes I don't know about myself. So, you know, if a question's overly broad or overbroad, you know, that can be hard to answer, confusing. There can be so many subparts. You can have like too many subparts that really it says 25 questions, but I mean, by the time you do the subparts, there's 5 subparts for every question, and guess what? Then you're back up over 100, 125 questions. So you haven't really accomplished anything by putting limitations on interrogatories. So this is what we call burdensome, which is to say that it's just too much, not fair. Now, what about somebody's mental health records? People, I've seen this, and I've actually done it, where you, the court is entitled to know about somebody's mental health status, but nobody else needs to know about it. And one of the problems I had in a case, the woman had been in a mental hospital, and the husband, the ex-husband, wanted to produce those mental health records in terms of trying to argue that the woman should not have any contact with her kids. So basically we got an order from the court on that to limit access to that information, which is called a protective order. And a protective order means that only the court can see these items, not other people. And the reason we did that is because there was a busybody second wife involved, and she was gossiping and telling things and going to the neighbors, going to this lady's neighbors and telling what a rotten person she was. You know, it's just terrible. So basically, when it comes to some touchy things like that, some people don't even want people to know that maybe they had cancer and they were cured or something like that. I mean, anything like that. So you can always ask for a protective order. Well, checklist on answers, most important thing is the calendar. I mean, you have to know when this is going to be due, and you want a calendar, and you want to be early on that. So in other words, if it's due in 30 days, you want to have this all done in 25 days and on its way, because you don't want to come running up against deadlines and shoot over the deadline. So that's a very important aspect. Always have copies. You give a copy to the client. You keep a copy. Indiana rules now require that you have an electronic, like CD. Used to be, it was a floppy disk, if you can imagine. But now it's like a DVD or a CD that you include when you send it to the opposing party. So you can make copies off there. You can open up the spacing between the questions so you have room for the answer under the question. That's how they want you to do it. They want you to have the question and then the answer. So basically you've got to keep on the client, because the clients, I'll tell you, this could be the case of their lifetime, millions of dollars, but they don't follow up on stuff. And so we have issues with that, and you've got to just kind of ride on them to get them to do this. So answering, a lot more important than drafting as far as keeping up with the time that is involved. So that's something to consider. Now, ESI, I'm going to cover that as a separate topic on a second DVD or video that I'm going to do here. So we're going to move forward. Like I said, drafting interrogatories, you always want to include an introduction. The introduction goes into what the rules are. So basically they both kind of have the same rules, but there's certain things about them that are specifically a little different. You want to look at the difference between state and federal rules here. Kind of start out Rule 33 and then move forward from there. So basically you tell them that they have to have interrogatories turned in usually within 30 days, but the problem that you can get into even on that is that some jurisdictions under local rule, and I know federal does this too, they shorten the time for response to like 20 days. So you got to be careful on that, is make sure you think it's 30 days, but double check it. Might be 20 days based on some kind of local practice. So you want to double check the local rules at the state level and double check the district rules at the federal level so that you make sure that you're getting the right information that you put into the drafting. And so here again, you need to identify the people that are involved, the parties that prepared the interrogatories, who they are, what their title is, their signature should be applied. You want some kind of proof that they are telling the truth, like notary, or you can also have affirmation. So these are important. Also, you need to know somebody's full identity, address, all that type of information. And then you basically want to remind them that they need to answer the question fully. And then you also usually add a part that says that the interrogatories are continuing, meaning if they answer, that may not be the end of it. You may have follow-up questions for them that are elicited based on what emerges from their answers, to the question. So basically here again, check on time. That's very important. Drafting interrogatories, you're basically wanting to establish the facts surrounding allegations. You've got the complaint. You want to get into more detail about how things happen. If the plaintiff is drafting interrogatories, you're basically wanting to get even right in the interrogatory an admission from the person basically that they're at fault, so that can be very, how did this accident happen, and so basically try to get them caught in some kind of an admission that's against their interest. If you're defending the case, for example, though, you want to elicit some answers that may point out, that there is comparative fault, that the plaintiff, even though they may have been injured, it was partially their fault, and then it's going to be up to the jury, just how much, is that percentage of fault, So those are important. Of course, those are the big nuts that you want to crack, but there can also be other important things, like are there, just like the case I've talked about before, are there other parties to the lawsuit? I totally forgot that the school bus driver could also be said to be negligent in that one case I had where the little girl was hit by the car, So, that's important, is try to get them to identify parties, their theories, things like that. Also, witnesses also. They may not be parties, but, do you have a list of witnesses? Identify those. You can put that right in the interrogatories. Now, some of these things like these admissions and so forth. You can also do what we call request for admissions, and we'll cover that in a later rule. Some things too, like about wages and stuff, you can subpoena that information in addition to asking for it in interrogatories. You want to do that multiple different ways. There's also a thing called a request for production. So when you get involved in this, you'll end up doing a lot of these different discovery methods just to follow through with each case. Okay, so another thing that's important is to talk to a plaintiff about their medical bills. But there's also issues when you're getting into medical. You can have them for the accident that you're talking about, but you can also have them for pre-existing conditions. Pre-existing conditions. And pre-existing conditions mean, let's say that somebody fell off a ladder like me and hurt their neck real bad. Well, then they go and they're in a car wreck and they're in a whiplash situation and they hurt their neck real bad. Okay, is that case going to be worth as much as somebody that hurt their neck for the first time? Probably not. Now the law says it can go either way, but a jury, I'll tell you, in Indiana, if they find out you hurt your neck before and then you hurt it again, they're probably not going to give you very much, if anything, honestly, which is kind of sad. Okay, so basically another thing you need in addition to your medical history is the bills for your medical. Okay, so what were the bills that you had? How much time did you lose from work? Okay, and what was that worth in terms of amount of wages that you lost? So these are all important concepts that need to be included in those interrogatories. Also, look through all the different documents. What's already been provided you. If you've got Rule 26 information where they provided you with a lot of information, you can draw information from there that you've got new questions. That's where you want to meet with the attorney that's working on the case, try to find out if he has any specific kinds of questions that he wants to focus on. You get into a thing where someone hasn't turned in their interrogatories in a timely manner, and that's like the bane of the plaintiff's bar, but you have an option called a motion to compel, and that's in one of the later rules, and we'll touch on that a little bit more later. But basically, if somebody doesn't turn in their interrogatories in a timely manner, then they will be hit with a motion to compel. So motion to compel, trying to force the person to answer interrogatories. So this would be party to answer. Answer. So basically what we end up with there is, first of all, answer. Tell us what this is all about. But then another thing you can get into is fees. Because if the attorney had to go to extra effort to collect or get that information, then he can say, well, I spent 2 hours on this, 4 hours, 12 hours, whatever it is, trying to get this information from you, and because of that, then you're going to need to pay me money because I had to go to extra effort to get you to do what you're supposed to do on your own. So that can get into a problem. For plaintiffs, it can be like a death sentence. If you make a pattern in your office, or in this particular case of not cooperating in discovery, a plaintiff, it's like a death sentence. A plaintiff's case can eventually be dismissed. Okay, so the first step is motion to compel. Failure to respond to the motion to compel results usually in a dismissal of the whole case. So, you don't even want to go there if you're working as a plaintiff's attorney or working for a plaintiff's attorney as a paralegal. And so very important, you want to be very careful to make sure that you comply with these things. Well, we'll work on some of these rules a little bit more, and we'll go into more detail on the ESI aspect. Remember that we told you what the definition of ESI, it's electronic stored information. So you want to keep that, and then anything else that you see that you consider to be important, be an important list of vocabulary words you need to get to me with the definition that you heard. If you want to follow up a little more and do a better job of defining it than I did, hey, that's fine. I'm kind of old school, so I kind of take some shortcuts, but it would be good to develop a strong definition for you to keep. Might not even be a bad thing to put in your trial notebook. Okay, well, hey, that's going to be it for this session. We'll be back with you and we'll talk more about this electronic discovery. We're going to do a little bit of a separate follow-up on the electronic discovery aspect. Thanks a lot. Hope this was helpful. Let me know if you have questions or problems. Thank you.